The National Broadcasting Company and the American Association of Colleges for Teacher Education, in cooperation with the American Political Science Association and the National Council for the Social Studies, present Continental Classroom, a course in the structure and functions of American government, conducted by Dr. Peter H. Odegard, Professor of Political Science at the University of California at Berkeley. And now, Professor Odegard.
The other day we talked about the President and Congress. Today I'd like to focus on the President's relation to the total field of administration. I don't suppose anybody today would agree with what Woodrow Wilson wrote in 1885 when he said that the business of the President is mere administration. The President, in fact, is part of the administrative, he says, rather than the political machinery of the government. Most students of the presidency today would almost certainly reverse this order of priority and would say instead that most of the business of the president is political and only in a minor degree is it administrative. Nevertheless, the president's responsibility for the administration and management of the federal government is not only important in and of itself, but it's important as a corollary of his political responsibilities. Because without power and authority to appoint and to direct the administrative officers in performing their duties, the president's political powers as commander-in-chief or as chief executive or in foreign policy would be little more than a ritual. The constitutional basis of the president's administrative powers can be rather briefly outlined. Article 2, Section 1, as you see on this chart, vests the executive power, says the executive power shall be vested in a president, just as Article 1 says that all legislative powers herein granted shall be vested in a Congress. The difference here is that Article 2 does not say the executive powers herein granted, nor does it say what the executive power is. Section 1 also requires the president, before entering upon his duties, to take an oath that he will faithfully execute the office of President of the United States. But this, too, is vague and ambiguous. What does it mean? And all officers of the government and the state governments must take an oath to support the Constitution. It's in Sections 2 and 3 that the President of Article 2 that the President's major administrative power and responsibilities are outlined. You'll find there, for example, as you see here, that he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices. And presumably, this includes the right to approve or to disapprove the opinions that they express and to substitute his own for theirs. And in this way, to direct the affairs of these departments. The President also has power, as you see here. The President shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for and which shall be established by law. Finally, the President is required, as you see here, to take care that the laws be faithfully executed. Now, these provisions of the Constitution, I'm sure, were intended to put the President in the driver's seat, to put the reins of executive and administrative authority in his hands. But it left a wide area of uncertainty as to the scope of these powers and as to how far they could be restricted or controlled by acts of Congress. The President of the United States, like the chief executive of any large organization, must operate through subordinate officials and agencies who carry on the innumerable functions of the government. His ability to see that the laws be faithfully executed depends altogether upon the character and ability of these officers to perform their assigned tasks and upon their loyalty not only to the United States, but upon their loyalty to the President and the policies for which he stands. Now, without power to appoint and direct his own staff, and without authority in that staff to direct the administrative officers in something like 2,000 departments and agencies of the government, no president could possibly be held responsible to see that the laws be faithfully executed. And without the power to remove faithless, incompetent, or disloyal officials, the president's power to appoint could be seriously impaired. As a matter of fact, to give the president the power to appoint and not give him the power to remove would be to tie one hand behind his back, because this would saddle him with officers in whom he had lost confidence. In addition to his powers to appoint and to remove key officials, the president must also have power to issue orders, rules, and regulations to control the administrative behavior of his own staff and, through them, of the vast army of federal employees. And secondly, he ought to have power to determine, within very broad limits, the organization and procedures to be followed in the operation of federal executive departments and agencies. The first Hoover Commission on the organization of the executive branch put the matter rather succinctly when it said, the president and under him his chief lieutenants must be held responsible and accountable for the conduct of the executive branch. And the report continued, responsibility and accountability are impossible without authority, that is, without the power to direct. The exercise of authority is impossible without a clear line of command from the top to the bottom and a return line of responsibility and accountability from the bottom to the top. These, it seems to me, are but elementary principles of administration which apply to the President of the United States as well as to the President of any business corporation. To the extent, in my judgment, that we violate these principles in public government, these elementary principles of administration, we make responsible, effective government impossible. And to the extent that we denied to the President the basic tools he needs in carrying out his executive job, we have no right then to complain if he fails in this Promethean administrative task that we have imposed upon him. And yet the fact is that in spite of his great powers, the President lacks many of the powers necessary for effective conduct of his administrative tasks. First place, he lacks adequate power to determine the structure and organization of the executive branch. This is done by Congress. Secondly, he lacks effective control over the federal budget. He prepares it, but Congress then decides what to do with it. He has no item veto, so that he must sign a bill in toto or veto it in toto. This means that Congress can put amendments upon bills that the President heartily disapproves, but which he has to approve or veto the whole business. That is to say, he's confronted with the job of throwing the baby out with the bathwater or saving the whole business. He's compelled to accept what he doesn't want in order to get what he does want. Again, the President's power to appoint and to remove even key officials is hampered not only by the political considerations that are inevitable, but by legal impediments imposed by Congress and upheld by the courts. His authority over administration is impaired, too, by the constant intervention of congressional committees in administrative management, and by the chairman of these committees encouraging bureau chiefs and agency heads to negotiate with them as chairman, and even to bypass, ignore, and on many occasions to even defy the President in the conduct of their duties. We have no time to explore all of these things, but I'd like to look at a couple of these problems. Congress, of course, sets up the major departments of government, but Congress has gone beyond enacting the ordinary basic law into determining its internal organization and even establishing administrative codes of procedure for it. It's also gone so far in the establishment of the qualifications of the officers whom the President may appoint as to severely restrict and limit the discretion of the President in selecting his own administrative officers. Citizenship, sex, age, and so on, these are common qualifications, but in addition, Congress will say that the President has to appoint people from a particular party, or they have to be apportioned according to parties. They have to be distributed geographically in a certain way, or they'll have to come from a particular industry or a particular branch of the government. As a matter of fact, one authority has said that Congress has contrived at times to designate such narrow eligibility as virtually to usurp the President's appointing power. In choosing his cabinet and his major department heads, the President, of course, is subject to the restraints of the political situation. He must appoint powerful people in his party, particularly those who helped him win in his election. Also, leaders in different sections of the country, or the leaders of rival factions in the party, or big contributors, and so on. These are political restraints and inevitable. Another is the custom of so-called senatorial courtesy. The President, that is, in making appointments, must defer to the wishes of senior senators and congressmen in making appointments in or from their particular states or districts. Now, the scope of presidential power to appoint, to direct, and to remove has been developed by law, by custom, and by the decisions of the Supreme Court. And I'd like to look at some of these to illustrate some of the problems that we confront when we look at the President as chief executive and administrative officer of the government. Let's take one of them. As a matter of fact, there are several of these cases we're going to talk about. You might look at them here. United States against Lovett, Humphrey against the United States, Myers against the United States, and In re Nagel. I don't know that we'd get to all of them, and we won't talk about them in that order anyway, but I thought you'd like to see the names. During the war, there were 3 employees in the Federal Communications Commission, 3 men named Watson, Dodd, and Lovett. And these 3 officials had been accused by the Dies Committee on Un-American Activities of disloyalty, or at least of having engaged in un-American activities. And the committee demanded their removal. The Federal Communications Commission conducted an investigation. The President conducted a review on his own and failed to find any evidence to support this charge at all. And the President accordingly refused to dismiss any of these people from their positions in the Federal Communications Commission. Whereupon, in the new Appropriations Act, Congress put an amendment into that act saying that no part of the funds herein appropriated can be used to pay the salaries of William Dodd, Goodwin Watson, or Morse Lovett by name, and they were not paid. Nevertheless, because they felt that they had not been dismissed by the president who had appointed them, they continued on their jobs and brought a suit for their salaries. Case came to the Supreme Court in 1946, the case of United States against Lovett. And the court held that this provision of the Appropriations Act was unconstitutional. It was unconstitutional because the court said it is a bill of attainder. It's a bill of attainder because it is a legislative declaration of guilt. What the legislature was saying here is that these men were guilty of something for which they'd never been tried in a court or had any kind of a hearing, and the court said this is a bill of attainder. And legislative acts that apply, and I'm reading from the court's opinion, that apply either to named individuals or to ascertainable members of groups in such a way as to inflict punishment on them without judicial trial are bills of attainder prohibited by the Constitution. So the Congress is apparently limited to the extent that it may not at least name people and say that you can't pay them if the president and the agency for which they work have confidence in their loyalty and in their competence. Without this power to remove, or rather, let me back up a minute. If Congress cannot remove in this way, how about the president? Can he remove officials? Because without the power of the president to remove, he can be saddled with officials who are incompetent or who are opposed to the policies for which he stands. Now, the most dramatic case in which Congress has undertaken to limit the power of the president to remove was the passage in 1867 of what was known as the Tenure of Office Act. We won't review that here except to say that this act was part of Congress's war against Andrew Johnson, and it prohibited Johnson from dismissing even members of his cabinet unless he had the permission of the Senate. Well, Johnson defied the Senate on this and defied Congress and fired his Secretary of War in defiance of the act, and it was this violation of the Tenure of Office Act that more than anything else was the basis for the impeachment charges brought against Andrew Johnson and which, as you know, failed. This issue of the president's power to remove and Congress's power to restrict it was never squarely faced by the Supreme Court until 1926. And in 1926, the court decided this issue in an important case, the case of Myers against the United States. The facts were briefly these. Back in 1876, Congress had passed a law which said, and I quote, "Postmasters of the first, second, and third classes shall be appointed and may be removed by the President by and with the advice and consent of the Senate, and shall hold their offices for 4 years unless sooner removed according to law." Well, on July 12, 1917, Myers was appointed postmaster at Portland, Oregon, for a term of 4 years under this law. But in January 1920, after Myers had served only part of his term, the Postmaster General asked him to resign, and Myers refused. Whereupon the Postmaster General, on the direction of the President, removed Myers from his job. Myers petitioned the President and the Senate for a chance to be heard on the ground that he couldn't be removed without the permission of the Senate. Failing in all this, Myers finally brought suit in the Court of Claims for his salary from the date of his removal until the expiration of his full term, which would not have expired until July 1921. That is, he sued for a salary amounting to about $8,800. The Court of Claims gave judgment against Myers, and so Myers proceeded to appeal to the Supreme Court of the United States on the ground that the President could not remove him under the law of 1876 without the permission of the Senate, since he had been appointed by and with the advice and consent of the Senate. The case reached the court. The Chief Justice at that time was William Howard Taft, who had been President of the United States, and I suspect Taft's experience as President had a profound effect upon his decision as a judge, because Taft said that the law is clearly unconstitutional, that the law of 1876, which said that the President could not remove officials appointed by and with the advice and consent of the Senate without the advice and consent of the Senate, is unconstitutional, because he said the Constitution, in effect, endows the President of the United States with a virtually unlimited power to remove all officers in whose appointment he has participated, excepting only judges of the United States. There's nothing in the Constitution, said Taft, which permits a distinction between the removal of a head of a department or of a bureau at the top in the President's cabinet and the removal of executive officers engaged in the discharge of their normal duties. The President alone and unaided, said the court, could not execute the laws, and as his selection of administrative officers is essential to the execution of the laws, so must his power of removing those for whom he cannot continue to be responsible. Now, this decision of the court, in effect, said that Congress cannot come in and interfere with the President's control of his executive and administrative offices. And this broad rule of the Myers case was the law of the land until about 1935, when it was challenged in the case of Humphrey against the United States. The facts here are also fairly clear. The law establishing the Federal Trade Commission had provided that commissioners were to be appointed by the President by and with the advice and consent of the Senate, and it provided further that any commissioner may be removed by the President for inefficiency, neglect of duty, or malfeasance in office. Well, Mr. Hoover, President Hoover, had appointed William E. Humphrey as a member of the Federal Trade Commission for a term of 7 years, which would not have expired until September 1938. But in July 1933, Franklin Roosevelt, as President of the United States, so only recently elected, asked Humphrey for his resignation. He said he thought Humphrey should resign because he didn't have any confidence in him. He didn't say that Humphrey was incompetent. He didn't say that he was dishonest or anything. He simply said, I'd rather select somebody of my own choice. Humphrey refused to resign. The President wrote him again in August and said, I'm sure you realize that your mind and my mind do not go along together on either the policies or the administration of the Federal Trade Commission. And frankly, I think it best for the people of this country that I should have the full confidence of members of these administrative agencies. And again, Mr. Humphrey refused to resign. So in October, Franklin Roosevelt, as President, sent him a very brief note saying, effective as of this date, you are hereby removed from the office of Commissioner of the Federal Trade Commission. Humphrey never acquiesced in this decision and continued to insist that the President had no power to remove him except on the terms prescribed by the Congress. And he insisted, therefore, that he was still on the commission and that he was entitled to receive his salary of $10,000 a year. That is to say, the president had not removed Humphrey for inefficiency, neglect of duty, or malfeasance in office, as the act said, but had removed him because he said Mr. Humphrey, as was very clear in the record, Mr. Humphrey and Mr. Roosevelt disagreed fundamentally on matters of public policy. The question before the court was the president's power to remove a member of the Federal Trade Commission limited to these reasons that Congress had written into the statute? This was the first question. And if it was limited, was this act itself constitutional? Could Congress impose this kind of a limit on the removal power of the president? Remember, Congress in the Myers case had held an act of Congress that undertook to limit the president's power of removal to be unconstitutional. Well, here the court takes a different line. It does not reverse the Myers case, but it distinguishes the Federal Trade Commission from a postmaster, for example. It says the Federal Trade Commission is an administrative body created by Congress to carry out certain quasi-legislative and quasi-judicial functions. And such a body, it says, cannot in any proper sense be characterized as an arm of the executive. And consequently, the court said that in the case of these agencies that are established by the Congress, presumably to be independent of the president and independent indeed of Congress, whose function it is to exercise not only executive powers, but quasi-legislative, that is, rulemaking powers, quasi-judicial powers to decide cases among contestants, that in these cases the president's power to remove would be limited strictly to those reasons set forth by Congress in the statute. And whatever one may think about this case, the Humphrey decision certainly puts a severe restriction upon the president's power in a vast area of public administration for which the president is ultimately responsible. That is to say, these so-called independent agencies and commissions.
This has been a pre-recorded NBC educational production.